Hello, everybody. Thank you so much for joining us today. My name is Ellen Burge. I'm a partner here in Washington, D.C. at the Venable Law Firm. I'm part of the advertising law group and was asked today to provide this webinar to you on subscription-based offers. We have lots of really great information and content in here, lots and lots of content. So hopefully you'll get what you need today. Maybe you want to watch this again twice or share it with your colleagues and follow up with us with extra questions. Before we get started, I was asked to read a few housekeeping matters for you all to help you get through the webinar technically and operationally. So first, at the bottom of your screen, there's multiple application widgets that you can use. These are resizable and movable, so feel free to move them around to get the most out of your desktop space. If you have questions during the webcast, you can submit them through the Q&A widget. We will try to answer these if we can. We have a lot of content though, and it might be easier for me to just answer your questions at the end, but nonetheless, please submit them. We'll get the questions answered one way or another. Also know that the webcast is being streamed through your computer, so there is no dial-in number. For the best audio quality, please make sure your computer speakers or headset are turned on and the volume is up so that you can hear everything that we say today. Let's see, if you feel like your slides get behind, pushing F5 on your keyboard will refresh the page and hopefully catch you back up to where we are. And if you have other issues, other technical issues that you need help with, there should be some additional help and answers to those common problems located on the help widget at the bottom of your screen. Okay, so with that, why don't we go ahead and get into our content here. I'm starting with some terminology very quickly because we float around a lot of different terms when we talk about subscription offers. A legal term commonly used is negative option feature. And the definition is written out here. It's an offer or an agreement to sell or provide any goods or services under which the consumer's silence or failure to reject goods or to cancel the agreement is interpreted as acceptance of the offer. That's a super wordy definition, very legal. The simplest way for me to think about it, and perhaps for you too, is just to know that these rules and this negative option terminology will broadly cover subscription programs, automatic renewal programs, membership clubs, continuity programs, trial offers that are often followed by a recurring shipping and billing program. So all of these types of things will be grouped into this presentation, sometimes called subscriptions, membership clubs, negative option, just so you all know where we are. Here's an overview of the legal requirements. This is going to sort of set our stage for today and take you through the agenda where we're going to get through. We've got various federal and state laws to cover. On the federal side of things, these are a little bit out of order of how we're going to talk about them, but the telemarketing sales rule, which the FTC maintains and enforces, has very specific rules for negative option offers in the telephone context, and that can be outbound calls as well as certain types of upsells on inbound calls. For online sales, which is where a lot of these sales go down, we think about the Restore Online Shoppers Confidence Act, also known as RASCA. We're going to talk a lot about RASCA today. Then we also need to think about Section 5 of the FTC Act. Well, we usually just refer to it as Section 5, if you hear me say that. Section 5 sort of closes the gaps where maybe the TSR or RASCA doesn't cover it. There's also some general things about Section 5 which generally prohibits false or deceptive or misleading content that will come into play with negative option offers and subscription-based marketing, so we're going to cover that. We'll next move on to the state rules. There are some state rules that cover automatic renewal programs, membership clubs. California, for the longest time, has had really the most comprehensive statute on this issue. It's the one that we've been following most closely. It was recently updated effective July 1st. So we're going to talk about some of the new California changes. There's a new Virginia law too that was recently passed and will go into effect in early 2019 that mirrors at least the old version of the California law that we'll cover a little bit. We'll mention some other things in the state laws on automatic renewals and things with notices and those types of issues. And then we'll also just make note that, again, like the FTC and under the federal standards, the states also have their own unfair, deceptive, misleading practices, prohibitions that can cover this type of marketing. Okay, so to move right into it, starting with RASCA, this is the complete part of RASCA that governs negative option programs. There's other parts of RASCA that we're not going to cover today, some provisions against data pass and some other things that were discussed years ago when RASCA was passed. But this is really the whole sum of RASCA as it impacts the automatic renewal provisions. And they write out very into three simple requirements, but of course they get very complex to judge whether you're meeting these requirements. But just to go through them individually, so we're all at the same page, RASCA requires three things. First, clear and conspicuous disclosures about the material terms of the transaction. And these disclosures have to be made before obtaining the consumer's billing information. And we're going to talk a little bit about when do you actually obtain billing information? Is that before somebody actually types in their credit card information, or is it whenever they're hitting the submit button? And there could be different theories on that. Second, RASCA requires that you obtain express informed consent before you charge the consumer and obtain their credit card information. So here, of course, the concept of informed consent means that somebody is agreeing to an offer after having been informed about the terms and conditions. So those two go together. And then the third piece of RASCA, providing a simple mechanism for the consumer to stop recurring charges, is fairly clear and straightforward. But there's actually a lot of there's recent case law and issues now about what is a simple mechanism, how easy must it be. Must it be online? Must it be by phone? Can it be either? So those types of issues are coming up in current cases and that we'll go through. So again, it all seems very straightforward, but it is actually very subjective on how you apply these requirements. And the standards are changing, I think, as new compliance trends come into play. Some new deficiency tends to take form. So we'll try to keep you up to speed on the latest cases. And also, while a lot of this we think about in an online context, I think most sales now are really being made on small screens, mobile phones. And so how something is set forth on a mobile device becomes really important as to disclosure, placement, and those types of things. So recent focus of RASCA enforcement, this is where we're going to head today to talk about a couple of cases. Of course, as you can imagine, a focus on whether disclosures are adequately made, even if they're made at all, is a focal point. And a lot of our earlier RASCA cases, or I think a lot of what was a driving force behind these RASCA provisions, was that there was a lot of automatic renewal offers out there that really had no disclosures whatsoever, or they were disclosures that were linked to in the fine print of a terms and conditions document or way at the bottom of a screen where nobody saw them, so they were effectively not made. Now, companies are putting disclosures on the websites, and it becomes more of a question of whether the disclosures are adequate. Are they clear and conspicuous? Can you see them? Those types of issues. And then the second enforcement trend is adequately disclosing how to stop recurring charges and providing, again, that simple mechanism. And what is that simple mechanism? So really, anybody who is running a subscription-based offer, a negative option program, a recurring billing and shipping can be impacted by RASCA. We've seen cases against all sorts of industries. A lot of people associate it with dietary supplements and weight loss programs and things like that, and that's true. But we're also seeing it with any other sorts of products and services, satellite TV subscriptions, fitness apps, dating services, those types of things. And the cases that we're seeing, and if you're wondering, am I potentially a target for an enforcement action, it's really driven by a high volume of complaints in most cases. Now, of course, staff of the FTC or of a state attorney general office can watches TV and they surf the internet, so they could certainly come across a case on their own, and sometimes they find out or get interested in cases because of other work that they're doing. Perhaps, for example, they're looking at the portfolio of a payment processor and they want to get a list of the companies in that payment processor's portfolio, and perhaps are looking at chargebacks or other types of trends that pique their interest. But complaints is a really important factor for you all to be watching if you're running these programs, just to see if consumers are understanding what they're getting into. And just to take a really quick pause there, I do want to mention this underscores the importance of compliance and sort of doing it right and providing good customer service and other things that we're going to talk about, and being on top of your lead generation and affiliate marketing, all of that sort of drives the negative option offer. Because if you end up with an investigation, either with a Federal Trade Commission type investigation or even with the state, they will ask for tons and tons of information about your offers, about your company. The requests, investigative requests, will cover things like, copies of all of your websites, mobile sites, and apps that you've used, each new version of it that you might have used over the last several years. They'll want to know who your payment processors are because, as I mentioned, they're frequently in contact with payment processors. They'll ask about chargebacks and refund rates and things like that they can investigators can easily get from them. They'll want to know all the products you're selling. They'll want to know, see all of your advertising, every ad you've put on Facebook or a Google ad or other social media ads, and look at sort of what you're saying to drive consumers to the checkout page where they're actually enrolling in your program. They'll look at customer data. They'll want all of the names and contact information and what people have purchased from you and whether they've asked for a refund and gotten it. And they'll look at sales data, profits, cancellation and customer service policies. We've had investigators that want to hear call recordings, and that gets particularly expensive because you often want your lawyers to review your call recordings before you send them over to the government, and that's a really time-consuming process. But as we'll talk about towards the end, what your call center reps are saying about the program can be really important. They'll want documents relating to all of this stuff. So I guess if why this is here is really just to say, do whatever you can to do it right, knowing that the standards evolve and change. But if you can stay out on top of your complaints and adjust as needed, you'll hopefully be in good shape. So let's now get into a couple of cases we'll go through in talking about ROSCA enforcement. This is a recent case. The complaint was filed about a year and a half ago against a seller of credit monitoring services. The final judgment actually just came through at the end of June this year, so this is why we're talking about it here. And this is an interesting case study to talk about. Here, what you have is a defendant who was selling a credit monitoring program. The allegations were that, and it was sold on a monthly basis. So each month you'd pay money, and this service would monitor your credit. And the allegations in the FTC complaint were that the disclosures about this program were not clearly and conspicuously made. The material, the terms and conditions weren't made, and then that the defendant failed to obtain that express informed consent before charging. There's some other background here to this case that you need to understand for context. This defendant, according to the FTC, had other issues. They were, as the FTC explained, posting ads on Craigslist, offering houses and apartments for rent, and then saying, okay, well, to actually rent this place, we need to get a copy of your credit report. So click here, fill this form out to get a copy of your credit report sent to us, and then we'll move forward with your housing application. And among other things, there was actually no apartment or house for rent, so there's obviously a problem there. But in terms of enrolling people in this credit monitoring program, the FTC outlined this case and said, look, consumers are really going here expecting just to get a free credit report and not to be enrolled in a credit monitoring program. So screenshot from the FTC's complaint of what it looked like. It might be a little bit hard for you all to see, and I'm sorry if it's a little small. And again, the interesting thing here is that there are some disclosures on the screen. In fact, in certain contexts, these disclosures might actually be sufficient if the consumer was expecting throughout the entire sales funnel that they were pursuing this path to get to enroll in a credit monitoring report, program. If the earlier marketing was about the benefits of being in a credit monitoring program, and this was the page you got to, perhaps that would have made a difference. But because there was some sort of misleading information given to the consumers up front, the FTC thought that these disclosures here were insufficient. And perhaps they are a little bit small, right? They're a little bit grayed out, and in the face of other things that you can see much more clearly. And this is the way the FTC would look at it. They'll look at the top headline and say, look, I'm here to get a free credit score and report, and I'm going to look at start here, and I'm going to try to figure out what I need to do to get going, and maybe not pay attention to that, the small disclosures that are grayed out. So here on this screen, this is, again, more from the same case. This is screenshots, again, from the FTC's complaint. This isn't all of the screenshots from the mobile app, but this is what the mobile version of the enrollment looked like at the time. And you could see, again, there's a lot of emphasis, the FTC would say, on sort of getting a free credit score and report. And the FTC sort of went through this. There was a few more snippets from the mobile site, but the FTC had said that there's no way in here that anybody's going to think that, to get the free credit score and rent the property that they're trying to rent, they're going to be enrolled in a credit monitoring program. So that was the issue here. This case actually, as I mentioned, got a final judgment and order entered just probably about a month ago. Here, there was the court that the defendants violated RASAS, Section 5, the Fair Credit Reporting Act, because of some of the free credit report information provided in the offer. This defendant agreed to a monetary judgment of over $5 million. And then, as with other FTC settlement orders and final orders that are usually entered, there's pretty extensive injunctive relief that really governs future conduct. And here, this defendant actually got a ban from selling any more credit monitoring services with a negative option feature. That goes right to the heart of sort of their issues. But there's, pages and pages of continuing language in there about, you can't misrepresent anything about the offer to the consumer, must make clear and conspicuous disclosures. Disclosures have to be made in close proximity to where a consumer provides billing information, and then other provisions about being clear about how the consumer can stop charges, how much they're going to pay, both during the trial period and then after the trial period ends, and when those charges will be put to their cards. I'm going to just cover real quickly. The ROSCA does not define clear and conspicuous disclosure or close proximity. Close proximity isn't necessarily in ROSCA, but it does come up in the FTC orders. And this is an example of sort of we get rule by consent orders and judgments that we read. It's they tend to become, even though orders really only apply to the defendant that's the subject of the order, they sometimes tend to become law in a certain way or a rule in a certain way that have to follow. So the clear and conspicuous definition, that is the current standard set out in this case and other cases that have been recent, are really that a disclosure has to be difficult to miss. It's got to be easily noticeable and easily understandable. We've seen the FTC take a preference for actually shorter and more concise disclosures, which is tough because you do need to say a lot of things about the offer terms. You know, when you're going to be charged, how much will be charged, how to cancel, but the sort of the clearer and more concise you can make that disclosure seems to be better. And you have to think about the median that you're using, and in the FTC's orders now, they'll sort of lay out different standards for different media. So, for example, if it's a television advertisement, the FTC thinks that the disclosure should be presented both in visual and audible portions of the communication. Visual disclosures need to be prominent by their size and their color and their contrast. And if it's an audible disclosure, it's got to be in a volume and a speed and cadence that somebody can really pay attention to. So no auctioneer type verbal disclosures. You can look at any of these cases and get a little bit more information on that. But the other thing I want to mention briefly too is this close proximity idea, and that's another one where it's worth following the cases and maybe even checking on the websites of defendants who come out of FTC cases with a settlement order and they continue to stay in business, and you know, they survive and they do well afterwards, but maybe seeing how they handle their order, because close proximity, you would think, again, I mentioned years ago, websites and things like that, if there were disclosures, they were made very, very far at the bottom of the screen or not even on the page at all. And then disclosures, you would started to see them get a little bit closer to the submit button, maybe even right to the left of it or right to the right of it. Now we're seeing a preference to have close proximity being like right there next to the button where somebody would click to consent to the offer. So right in the same zone, even putting a box around it or something. But these two concepts of clear and conspicuous and close proximity, again, they're very subjective, they're contextual in a way, but they're really important for trying to make sure that you've complied with the law and met current standards. Another, just to wrap up on this judgment in order in this particular case of the credit monitoring, some other things that came out of this, a requirement that this defendant has to send written confirmation of the transaction by email, and that confirmation has to repeat all of the disclosures about the negative option offer. That's worth doing anyway. That's not in RASAS law. It is in California law, which we're going to talk about, but it is it's helpful to know. I know there are some businesses that might be nervous about doing this, reminding people to cancel, and they don't want to generate a cancellation from it, but it really is good practice if you can find a way to do that. The other thing here in this order, it has to obtain consent through a checkbox or a signature or other similar method that the consumer can use to affirmatively select and accept the negative option feature, and no other portion of the offer. So again, when you think about what your disclosure will be, we've seen companies now that will make their ROSCA disclosure as concise and clear and comprehensive as they can and put a checkbox right next to it. But it seems that by this no other portion of the offer language, you can't then also tack on in the end that somebody is, by checking the box, agreeing to your terms of service or your privacy policy. And so therefore, do you now need two check boxes? And is that making things sort of really an extra step and complicated and complex for the consumer? But that no other portion of the offer language is something that we'll have to watch and pay attention to. And then finally, a requirement here, as ROSCA requires, to provide a simple cancellation mechanism. And in this case, even though this is not a ROSCA requirement, in this order, the defendant is required to provide an online cancellation mechanism if the consumer actually enrolled in the program online. So that's also a California issue we'll get to, but you can see how an FTC order, and this is similar to recent FTC orders and other cases. So you can see how FTC orders sort of start to evolve the standard and narrow down or be more specific than what the law requires. More on cancellation mechanisms. This has come up in another recent case against Adore Me. This is a company that sells apparel online. They have a membership program. It's $40 a month. You put money into sort of your account and you use it and get credits, and you can use those credits later to buy apparel from this website. And again, another, not on the slide, but just for more background here that you should have is that one of the program terms that this company had was that you'd forfeit the credits if you terminated your membership for any reason. And the FTC had alleged that this credit forfeiture wasn't clearly disclosed. There were also issues with consumers who would initiate a chargeback against this company. If the company found out about the chargeback, then the FTC was terminating the consumer's account and forfeiting their credits without really telling them. So in this case, the FTC thought that this company had forfeited over almost $2 million worth of consumer credit. So it became an issue. But the ROSCA type of issue here was that the FTC thought that this company really created a barrier to cancellation by making it difficult for consumers to get you on the phone, or if you were able to call in and finally, after waiting 11 minutes, in some cases up to 32 minutes, the FTC was finding, once you finally get through on the phone, the rep would tell you, oh, you need to actually go online to submit your cancellation. And then that became confusing and difficult. So this drawn out cancellation process was a problem. I guess at one point also there was a request by this company that to cancel you had to answer 5 questions, like a membership quiz online, and go through multiple web pages and look at other things before you could cancel. And that is not the type of simple cancellation mechanism that the FTC thinks that ROSCA required. So this became sort of the ROSCA focus of this case. And in the settlement that this company entered into, that became a feature of the settlement. There were other things in the settlement. There's usual lengthy provisions, as there are in the other ROSCA settlements, about making adequate disclosures online, obtaining express informed consent, a requirement to send that email confirmation, like in the last case we just talked about, and those types of things. But here, that cancellation mechanism, I think, was the feature point. So again, simple cancellation mechanism. Consumers have to be able to find a way to stop the recurring charges. The cancellation mechanism can't be costly, confusing, time-consuming. Here again, you'll see if the consumer enrolled over the internet, then this defendant has to provide a cancellation mechanism over the internet. Or if the consumer enrolled over the phone, then the phone is the way to go for cancellation. And then some extra language there about calls being answered during normal business hours, retrieving your mail quickly. I would say, just as a general principle, the same goes with email cancellations. If you're going to allow your consumers to cancel by email, you've got to make sure you're checking that email inbox, because a lot of times those can go unattended. So, and then this company paid a significant monetary judgment. Okay, so just to wrap up with the FTC, here we have the telemarketing sales rule. This really will only apply to your telemarketing sales, and the TSR is an interesting thing because it applies to outbound sales calls. It generally does not apply to inbound calls, but it does apply to upsells that are offered on an inbound call or an outbound call. And the upsell is, after the first purpose of the call is completed, maybe somebody calls you because they have a customer service question, and you decide that this is a good chance to sell them one of your subscription-based programs to help them with their issue. That's an upsell, and that sale then is a new transaction on the phone, and it's subject to the TSR. So the TSR has been around for a very, very long time, and these provisions have been in there for a long time. And in fact, before ROSCA, this was still sort of the guidelines for internet sales, even though, internet sales are not over the phone, but the FTC could use Section 5 and sort of take the TSR requirements and use them as a guide for online violations. But again, simple stuff. You have to disclose that the account will be charged. The consumer takes an affirmative action to cancel or avoid the charges, the dates the charges will be submitted for payment, and the specific steps the customer must take to avoid the charges. There's also a requirement in the TSR to obtain express informed consent. Again, we've talked about this. So informed consent means somebody knows what they're consenting to. Express consent really means explicit consent. So you want to make sure you're getting a clear yes or no to a very clear disclosure of offer terms when you're on the phone. So we will keep going. So, and just one quick note, this comes into play when you really want to take a close look at your telemarketing scripts. So you really need to pay careful attention to how those are written, and then I would listen to phone calls and see how your sales reps are doing when they read these scripts, or your third-party call center. Do some quality assurance checking and make sure that the disclosures are being read and not skipped over. I think this is our last section on the FTC, but we do need to talk about Section 5. I mentioned this earlier, sort of the end-all be-all of sort of the FTC coverage. It prohibits unfair or deceptive business practices. So that's going to cover any medium. It doesn't necessarily need to be online or over the phone. This is something that could cover, like, think of a advertorial that you might have, or some content you put online, or even a banner ad or some other ad that you have to drive somebody to your website where they can enroll in your subscription program. And these things come into play, and everything that you do to get somebody to come to your website becomes really important. It becomes it could be a deceptive or a misrepresentation if you say, for example, that something is free, or you can get a trial or a sample or a bonus, or try this for no obligation, and you don't tell somebody at that time that you make the representation that this free offer is contingent on their recipient enrolling in or accepting a subscription program. And so we have seen some companies be a lot more clear about what it means to get a free sample. Here's one example. This is, in my view, a good example. I don't know how others would feel about it, but I like this example. This is actually on the landing page of a website. You could see it says free sample, and then I would say in close proximity that, here it says, and sorry, I have to look here, but the sample offer includes monthly shipments at a guaranteed low rate. There's a link to get more details, but at least there's some hint there that there's something more to this offer than just a free sample. So if you could work more of these types of aids and guides into your marketing before somebody actually gets to the page where they're enrolling in a program and checking out, I think the better off you will be. So other Section 5 stuff, and these come out in the settlement orders. They come out in the ROSCA cases, but they're really Section 5 issues. But these are examples of a common provisions that the FTC puts in its orders. But again, saying that you could get something just for shipping and handling without indicating that there's more to it. Misrepresenting the purpose for which you're collecting billing information. So this could be something like, just provide your credit card information to pay $4.95 shipping and handling today, period, and you're not saying anything else. Misrepresenting that a transaction has been authorized by a consumer. We see this a lot in call center recordings for customer service calls. So you almost get this notion of somebody blaming the customer and you hear a rep saying, well, you checked the box, you authorized it, when you've got the customer saying, well, I had no idea, you told me I was going to get this, I just went through and placed my order. So that actually can come through as a Section 5 problem. Cancellation, exchange, and refund policies can be a problem. This had come up in the previous case we talked about with that store credit policy. And then also issues with sort of false inducements to make a quick decision. Here's an example from a case: hurry, supplies limited. We also see things like, maybe you've seen a countdown clock where this offer is only available for the next 2 minutes when that's not really the case. And all of these types of things kind of taken together can pose a problem. Maybe individually on its own, if everything was perfect on the website and you had perfect disclosures and everything was very clear and the right checkboxes and all that type of stuff in the right spots, maybe a false inducement isn't going to get you so much in trouble, but it certainly is an add-on issue whenever there's other problems. So, all right, we'll take a shift here and move on to state law, and we're going to spend some time going through California law. As I mentioned, California has had law in place since, I think, December 2010. California district attorneys and local counties have been very aggressive, actually, in enforcing the law. I think it's been, in some ways, probably good for revenue generation with them, but lots and lots of companies have been duking it out in California over the sufficiency of their disclosures, and oftentimes disclosures are present, and it becomes a sort of a battle of whether subjectively do you think a consumer would have seen these or not, or did the consumer see them? So this goes back to my earlier points about all the stuff that an investigator would look at to try to figure out, did consumers understand and see your clear and conspicuous disclosures or not, by looking at refund rates and chargebacks and listening to call recordings and those types of things. But anyway, California is a good standard because it's very it's pretty clear. It's more specific than we see under RASCA. If you've complied with the California standards, you're probably in pretty good shape under RASCA, assuming that placement of the disclosures is okay and all the other things are in place. But to go through these really quickly, you've got to disclose that the agreement will continue until the consumer cancels. You have to describe the cancellation policy that applies to the offer. I think that's an important point. How much is the consumer going to be charged to their account on a recurring basis? How frequently will they be charged? That's the length of the automatic renewal term. If you've got a term that's, for example, 6 months, you say it's 6 months, or if it's continuous, you have to let them know that it's continuous. And if they have to do it, the program for any minimum period of time, that's got to be disclosed. And then I mentioned earlier that California enacted new components to its automatic renewal law that just took effect July 1st. So we've tried to put them here and put them in red so you can see sort of what's new. But there was a concern over free trial offers in California and sort of an issue with luring somebody into a free trial offer, or maybe it's discounted, and the price that somebody will pay after the trial period ends is not always clear because the trial price is so good. So just making sure that that's clearly disclosed to consumers is something that now the law covers. So where do the disclosures have to be? Clear and conspicuous, like we've been saying all along. And here, California actually does set forth a pretty specific standard within its own law on this, whereas, as we talked about with the FTC, we sort of get it from orders. But in a written context, which would include online or print, larger font type than surrounding text, contrasting type, font color. You have to think about all of these components as you're making your disclosures to make sure they can be visibly seen. And then in oral disclosures, again, a volume, a cadence that can be readily heard. And then the other important thing to know, too, is that on the telemarketing context, you've got to make the disclosures before you're actually agreeing, having the consumer agree to be charged. So important placement issues. California also has an affirmative consent requirement. They actually, the new thing here is to make sure that there is consent to, the consent includes an understanding by the consumer that if they've gotten something for sort of a discounted price for some trial period or limited period of time, that the consumer's understanding that that trial period is a trial period and the terms will change after that and what they will be. So again, that's part of the new language here. And California doesn't actually define affirmative consent. We can get sort of what it means though by other things, as we've talked about. FTC has dealt with placement in its orders. There's a strong preference for a checkbox, something that is not just a submit button or place my order button, but actually an affirmative unchecked checkbox that the consumer could check to accept the terms. And then in the telemarketing context, it's really about getting a really explicit yes or I agree, whatever makes sense. You kind of don't want to rely on somebody saying uh-huh or an okay or something that's not, okay might be okay, but it depends on sort of if the consumer is kind of not really, if they're half listening and they're just saying uh-huh, that's something you have to watch out for. So offer acknowledgements, these have been in place for a while, and we mentioned this earlier that while the FTC has put offer acknowledgements into their orders, California actually has it as part of their law. So you do need to send this acknowledgement. It's kind of like an order confirmation right to the consumer right after the sale. They've got to be able to keep a copy of it. Email should be sufficient there, but it's got to repeat the terms of the offer, the cancellation policy, telling the consumers how to cancel. Again, this is for California consumers, so this is what you would do if your customers in California. And then if the offer includes a free gift or trial, you also have to disclose how to cancel before the consumer actually ends up paying for the free goods or services. And that's in those cases where it's free to try for 2 weeks, but if you keep it and like it, you're going to end up paying for it. So material changes after a consumer has accepted the offer. So this is, let's say you change the price. It's now $29.95 instead of $19.95. You do need to go and provide the consumer some notice of the material change and remind them that you can cancel this and this is how you cancel, so that if they don't like the change or the new price or the new terms or whatever it is, they can get out of the offer. Cancellation mechanism. This has become a big one. The change in rent has become a big one. There's always been in California law, a requirement to have a phone number, an email address, a mail address, some other cost-effective, easy-to-use mechanism to cancel. But now California does require that if your California customer enrolls in the offer online, they must also be allowed to cancel exclusively online. So it's not that they must cancel online. They could still, if you allow them, call you or send you mail, but you must provide that online cancellation mechanism so that they can do it online if they want to. And that's really to make things easier for the consumer. The online cancellation mechanism can include a termination email that you have pre-formatted and provided to the consumer. I wish I had an example of that. I actually have yet to see one, maybe because I don't live in California, so I haven't enrolled in anything where I might see this. But if anybody has an example of what they're doing here and it'd be share it with me, I would love to see it. So some quick questions. Why did California change its law? Particularly with respect to the online cancellation mechanism, California was finding that consumers were getting just a little bit frustrated with, okay, well, it was easy for me to order online. I didn't have to talk to anybody, but now to cancel, I actually have to call. I have to sit on hold. Then I have to talk to somebody who's probably going to try to convince me to cancel, or maybe try to sell me something else that I don't want. And that wasn't what California wanted for its consumers. So they did this really to make it easier, avoid that human interaction if you want to, avoid this conflict between a simple online sign up versus that complex cancellation of having to go through all those issues, and then avoid those high pressure customer retention tactics that consumers were complaining about. We've had a few questions come up with California law afterwards. And let me run through these quickly because we are running a little bit short on time. But the July 1st provisions, as far as I can tell, are not retroactive. So it's everything that you're enrolling after July 1st has to do this. We've had people ask if they must actually advertise the online cancellation mechanism to California consumers, or can they just sort of slip it in there and provide it? I would think, this is my answer, I'm not sure what the exact right answer is, but I would think that since you actually have to make disclosures about your cancellation policy and how to cancel for California consumers, that how to cancel would include canceling online. So to me, it's no different than telling somebody when they have to cancel by. Identifying who your California consumers are. Again, I'd love ideas on that you all might be doing. A lot of people are looking at billing addresses or shipping addresses. Some people are trying location method with the IP address, but my understanding is that might be problematic. So, and then we've had people ask, do we have to go back and provide this online cancellation mechanism to people who weren't first California consumers, but maybe they became California consumers, and an answer set in stone on that with any authority. It would seem to me that it seems like a lot. I would think that the rule would apply at the time somebody enrolled, but I think that's something we can think about and watch. And cases inevitably will come out on these issues. We'll have to update you on cases and see how these things go as more enforcement comes. So we're going to go through the cases really quickly. The point here is that, as I made earlier, California counties and cities are enforcing this law. The enforcement goes a lot like it does with the FTC. They'll allege that, you didn't make clear and conspicuous disclosures. You've got to fight that out with them. A lot of companies end up settling. Here's the EHarmony settlement. You could see what they agreed to pay. And here they actually also in California you'll have to pay their investigative costs. So not only you gotta get hit with a double whammy there. The orders end up with also injunctive relief. The EHarmony settlement terms here are a lot like what you might see with the FTC. So, have to make the disclosures, have to obtain consents. Here, if you look sort of towards the middle, that underline language, again, it's like what you see with the FTC orders. Have to use a checkbox so somebody can accept the offer terms and no other terms. Again, does that mean 2 checkboxes, or what do you do about somebody accepting your privacy policy in terms of use at this point? So dealing with those can be a little bit tricky. The email confirmation and other cancellation mechanisms came out in the settlement. Dropbox, also a recent case here from May, much like the same, found to have insufficient disclosures about its Dropbox Pro service, agreed to injunctive relief. Another thing here, the last bullet, there was a part of the agreed to provide notice of upcoming charges, specifically for service plans that have a renewal period of longer than 1 year. And that's something that actually comes in on other state laws. We're going to get to that in just a second. Class action lawsuits, know that class action risks are there for you too in California. There's some question about whether the California automatic renewal law actually allows for private causes of action, including class actions. There's a case from not too long ago where the court went through this analysis and thought that it didn't think so, that there was no private right of action for consumers to enforce the automatic renewal law. However, you can still, as a private class action plaintiff, enforce the automatic renewal law by alleging it's an issue under California's unfair competition law. So there's a loophole, I guess, or a way for class actions to go forward in California, and there's a lot of them, and they're just maybe even sometimes more of a pain dealing with than other things. So Virginia just passed, as I mentioned, a new automatic renewal law. It looks just like California's law without the July 1st updates. So if you're familiar with California law, you'll now be familiar with Virginia law, but it's Virginia notably does have a private right of action in their law, so that's concerning perhaps. And we're wondering if this is the beginning of a trend. Are more states going to follow? This now makes it a little bit fuzzier in segregating out your California consumers and dealing with them one way, when now you have another state to deal with, and potentially there's more to come. So state actions come up all the time. They've been around historically. There's a mention here, and if you re-watch this presentation later, or you can sort of pay more attention to the slide, but this all kind of comes up under the little mini FTC X, as we call them, just general consumer protection statutes that prohibit unfair or misleading, deceptive marketing practices. So these cases have been around for a while. You've clear and conspicuous disclosures, consent, all those types of things. And here again, the third bullet in the small list of bullets down towards the end, you'll see a requirement in this order to provide advance notice of upcoming automatic renewals for plans that are lasting longer than 6 months. Which leads us to renewal notices, not required, as far as I know, under any federal law, but state laws do sometimes require them. We have a slide next on some of these state laws, but they do depend a little bit on sort of what you're selling. Sometimes a renewal notice only applies to a very specific type of product or service that you might have in the state. Health club memberships, for example, security services, I think, is covered by one state. As you know, and as we've talked about, these renewal notices are sometimes mentioned in some of the orders. But a lot of companies do use them whenever they do have a longer renewal period. When a consumer is getting something every month, they get that product or the service, and they see it on their statement, hopefully, frequently enough to remember that they enrolled in this plan. But when it's much longer, consumers tend to forget, and that might drive complaints. So even if it's not required, might be a good practice for you if you have a long period. So here are the couple more points that you can look at. Some of those renewal periods, again, it depends on sort of the term of your renewal. It's usually something that's more than 6 months in renewal, or even longer than 31 days. Apply to what your offer is. And, sometimes they might allow you to send notice by email. Sometimes they specify mail, but certainly something to look at, because if you don't comply with the state requirements, the state may deem your product or service as an unconditional gift or void the entire sales transaction. So important there. Last couple of slides, and I think we're running short on time. So quickly, as I'll mention, it's not just the offer. Again, it's not just sort of that point when you have somebody on your checkout page and they've selected the program and they're putting in the shopping cart and checking out. Everything that you do leading up to the sale becomes important. This is just an example. This is an older case now. This is from a 2014 case, but this is an example of somebody that was selling green coffee extract. They were playing off of a Dr. Oz craze and selling this as a weight loss program, and using what the FTC alleged to be fake news websites to sort of provide, in this case, an account from a journalist who tried this product and actually thought it was really great. And if you want to get yours, click these links. This became an issue. These types of things can be problematic. This gets into your affiliate marketing programs. What are your affiliate marketers doing whenever they're driving traffic to your sites? Whenever they're, what are they saying about the program? What are they saying about getting a free sample? All of these things you're ultimately responsible for. So remember with your affiliate programs to make sure you know who your affiliates are. You've got really good contracts with your affiliates that set forth the do's and don'ts of what they can't do. And perhaps most importantly, you're monitoring what they're doing and ready to terminate them if they're generating lots of high risk traffic to you. And you can usually tell that because their programs are more successful than others. And you might want to look at those and see if there's an issue there that's going to ultimately get you in trouble. So affiliate issues actually come up in a lot of the RASAS cases, and they're discussed there too. And then on the back end, Customer service, we've talked about this already, so we don't need to go through it more, and this is the last slide actually, but again, what are your customer service agents doing on the phone? Are you incentivizing them to keep somebody in the program? Are you paying bonuses out to them? Are they sort of blaming the consumer for not reading the terms that they think were so clearly put on the screen and that the consumer doesn't think so much? Are they saying, hey, instead of canceling today, why don't you keep your free trial for another 2 weeks and call me back if you don't like it, without being really clear that, okay, at the end of that 2-week period, then you're going to be charged and then charged again every 30 days. So we've actually done a lot of exercises here where we've listened to a whole bunch of call recordings, 100 call recordings, and just sort of do an analysis of what your reps are saying. And it can be really helpful to do that type of thing. If you're using a third-party call center, you want to pay attention to what they're doing, monitor them, do quality assurance checking, check the agents, be ready to get agents off of your campaign if they're not adhering to what you need them to do. But again, think about everything you do, from everything, the whole life cycle of the customer, from lead generation to the sale to customer service, and it really does all play into your subscription offer. So I think I have used every last moment of my time. So I hope that you were able to send in some questions. Here's my contact information. Would be happy to talk with any of you. If you'd like to call, send me an email, and I will do my very best to get back to all of you. And thank you so much for joining today.